welcome everybody. Happy International Women's Day to everybody, wherever you may be as well. My name is Dr. Emily Jones, and I am the co-convener along with my colleague and your chair for this evening, Dr. Megan Wong, of the Essex Public International Law Lecture Series. It's my absolute pleasure to be your host for today, or evening, afternoon, morning, wherever you are. I know we have multiple time differences. And this is our second Law of the Sea event, so we're very, very happy today to be hosting that. We're very pleased today to have with us His Excellency Judge Kittichaisaree, and I will hand over to Dr. Wong shortly to introduce His Excellency. However, before I do that, I just wanted to say a few words about the series itself. The Essex Public International Law Lecture Series is co-convened by myself and Dr. Megan Wong. We are both international lawyers. However, Dr. Wong is a formalist and I am a critical international legal scholar. So we work from quite different perspectives and we navigate different circles, but we share a deep respect for one another's scholarship. This series is therefore really built upon that respect for one another, but also upon our friendship. So the Essex Public International Law Lecture Series consequently prides itself on bringing together these two very important traditions of international law, formalism and international legal practice, and critical international legal theory. So as you may have seen, we've already had the pleasure of hosting several excellent speakers this term, including our inaugural lecture, which was given by Professor Niels Blocher, as well as we've had lectures as well from Professor Larry Marceau, Dr. Dina Zubala, Lucia Solano, and Professor Marty Koskiniemi. We do have two events left this term as well. We have Professor Hilary Charlesworth in 1 week's time and Professor Campbell McLaughlin QC. But today, of course, we are pleased to be hosting His Excellency Judge Kittichaisaree. So as I said, Dr. Wong will shortly introduce him, but I wanted to also first take this opportunity to thank His Excellency, who has kindly acted as a guest speaker on our LLM and International Law of the Sea module this year. So we have some very lucky students with us at Essex. And I'd like to thank him on behalf of Dr. Wong and Dr. Antonio Coco, who are the co-teachers of the course, but also on behalf of our students, who I know were really excited to be taught by His Excellency. So I would now like to take this opportunity to introduce you to Dr. Wong, who will be your chair for today. Dr. Megan Wong is a lecturer at the University of Essex and is currently the postgraduate director of the LLM and International Law degree. She also directs the LLM and the International Law of the Sea module, which is co-taught, as I said, by our colleague, Dr. Antonio Coco. So the topic of today's lecture falls very much within the expertise of Dr. Wong, because she is a generalist international lawyer with a particular interest in the law of the sea. She has published on canonical topics of international law and has advised states on a broad set of issues in international law. She holds a PhD from the University of Leiden, an LLM in Public International Law for the University College London, and was called to the bar in England and Wales. Dr. Wong is also the author of a forthcoming monograph with Cambridge University Press entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. So, Dr. Wong, over to you.
Thank you, Dr. Jones, for the kind introduction. And as well, good afternoon, good evening, good morning from where in the world you are zooming in from. I'm honored to chair today's lecture by His Excellency Judge Kittichaisaree, entitled International Tribunal for the Law of the Sea, Upholding the Rule of Law at Sea. Some housekeeping rules before I introduce His Excellency. This lecture will be followed by a Q&A session. Please feel free to ask your questions in the Q&A box throughout the lecture, and I will read out your name and affiliations unless you opt to be anonymous. Now, let me tell you more about our distinguished speaker today. His Excellency Judge Kittichaisaree is currently a judge at the International Tribunal for the Law of the Sea and former ambassador of Thailand to Iran, Australia, Fiji, Papua New Guinea, Solomon Islands and Vanuatu, Russian Federation, Armenia, Belarus, Moldova, and Uzbekistan. Judge Kittichaisaree was a member of the UN International Law Commission in 2012 to 2016, where he was responsible for the ILC's topic, obligation to extradite or prosecute, and he was also the chair of the UN General Assembly's 6 committees working group on the administration of justice at the United Nations. His Excellency was a Thai career diplomat, where he was also the Director General of the Department of International Organizations until the commencement of his 9-year term judgeship at the tribunal in October 2017. His Excellency's illustrious diplomatic career spans across a broad range of international legal issues, but today I want to highlight His Excellency's many important contributions to the international law of the sea. Judge Kittichaisaree was the head of the delegation of Thailand to the Preparatory Commission for the International Seabed Authority and for the International Tribunal for the Law of the Sea, where he was elected the chair of the group of 77 of the whole. His Excellency was a Thai delegate at the meetings of the ad hoc open-ended working group to study issues relating to the conservation and sustainable use of marine biological diversity beyond areas of national jurisdiction, and the Preparatory Commission on the Development of an Internationally Binding Instrument under the UN Convention on the Law of the Sea, the BBNJ. His Excellency is a conciliator under Annex 5 to the Convention, Annex 7 to the Convention, and a member of ITLOS Seabed Disputes Chamber, Chamber for Marine Environmental Disputes, and Committee of Rules and Judicial Practice. Judge Kittichaisaree has also made a significant contribution to scholarship in the law of the sea, as His Excellency has published widely in this field and other fields of international law, including the law of the sea and maritime delimitation in Southeast Asia with Oxford University Press, and articles in leading journals. Today, His Excellency's lecture features this book, which is one of the first books in the Elements of International Law series by Oxford University Press. And the idea behind this series is that it will focus on concise and accessible doctrinal treatments of core international law topics. Although His Excellency has contributed to other fields of international law in various multilateral settings, the law of the sea is clearly close to his heart. Judge Kittichaisaree wrote his PhD thesis at Cambridge University on the law of the sea and the protection of states' interests in maritime natural resources, with special reference to Southeast Asia. So a personal inspiration to us, international lawyers from Southeast Asia, but also to international lawyers everywhere across the globe. Thank you, Judge Kittichaisaree, for your service to the codification and progressive development of international law, and also for upholding the rule of law at sea, which is what we are here to listen to today. So, His Excellency Judge Kittichaisaree, the floor is yours.
Thank you very much, Emily and Megan, for the kind introduction. And it's an honor to be here. And I also have to be very careful that there are so many participants in this lecture, and the level of knowledge among the participants may be, some may have elementary knowledge of the law of the sea, whereas the other are experts. So I try to strike the middle ground by making my lecture comprehensible to everybody. First of all, I have the PowerPoint to share with you, starting with the next PowerPoint. I introduced you to what the law of the sea or ITLOS is. So next PowerPoint. Okay. At this moment, the 1982 Law of the Sea Conventions has 168 parties, including the EU and State Palestine, Cook Islands, and Niue, which are not member states of UN, but we are recognized as parties to the Law of the Sea Conventions. And the dispute settlement part of the Law of the Sea Convention appears in part 15. And this had to be read in conjunction with Annex 6 of the convention, which is the statute of the tribunal itself. The tribunal is based permanently in Hamburg, but we may exercise our jurisdiction deciding cases elsewhere. And now we have been able to do that in Singapore since we have concluded an agreement with Singapore for us to sit as the full tribunal or as a seabed dispute chamber to render judgment or advisory opinion in Singapore, if the parties so desire, if the tribunal find it appropriate to sit in Singapore. And interestingly, Bahrain and Argentina have also expressed interest in having tribunal to exercise our function there from time to time. So the tribunal has 21 judges elected by 2/3 majority of state parties. Before election, the UN will calculate the number of the quorum in the room. There must be at least 2/3 state parties in the room before the vote. And then after that, the judges who are elected must receive at least 2/3 majority of state parties present and voting. We are elected for 9 years and maybe re-elected for further terms. The longest duration a judge of ITLOS has served is 24 years consecutively. And why 21 judges and not 15 like the ICJ? The convention foresees that ITLOS may constitute several chambers. First of all, seabed dispute chamber with 11 judges and other specialist chambers with 10 of 9 judges. So in order to make it possible for all the judges to sit in separate chambers at the same time if required, the number is increased from 15 to 21. So let's see the next PowerPoint. The tribunal has mandatory jurisdiction over 2 types of cases. The first one, from release of detained vessels and crews under Article 292. The second one, prescription of provisional measures pending the setting up of an arbitral tribunal. I will come to that later on. And as I mentioned, we have the seabed dispute chambers, which is the tribunal within the tribunal itself, comprising 11 members elected for 3 years term. It has mandatory jurisdiction over disputes regarding activities in the deep seabed areas, mainly deep seabed mining and other related issues. Next. These 2 provisions are very crucial to understanding ITLOS. And unfortunately, they are not properly understood even by law of the sea experts. Article 20 of the statute says ITLOS is open to state parties to the 1982 Law of the Sea Convention and entities other than state parties. In any case, expressly provided for in Part 11, that is deep seabed mining and other things in the area. Here, the convention foresees situation where contractors, state enterprise, and non-state entities may have disputes regarding their activities in the deep seabed mining field. And Article 20 allows them to be parties to dispute before the seabed dispute chamber. And beyond that, Article 20 also allows the tribunal to adjudicate on any case submitted pursuant to any other agreements conferring jurisdiction on ITLOS, which is accepted by all the disputing parties. You see, any other agreements accepted by all the disputing parties. So this allows something beyond state parties of UNCLOS. Article 21 elaborates further that ITLOS jurisdiction complies all disputes and applications. We have interpreted the word applications to mean applications in contentious case involving disputes submitted to tribunal in accordance with UNCLOS. And here we have very interesting provision, and all matters specifically provided for in any other agreements which confer jurisdiction on ITLOS. In ITLOS jurisprudence, all matters need not be disputes. It could be requests for advisory opinions or legal matters. And these matters may be submitted pursuant to other agreements outside ITLOS itself, provided that that agreement confer jurisdiction on ITLOS. Next. Article 22. If all parties to a treaty in force, here I stress in force, and concerning subject matter covered by UNCLOS so agree, any dispute on interpretation or application of such treaty may be subject to jurisdiction of ITLOS as well. And Rule 54, paragraph 5, allow ITLOS to accept cases where the party somehow implicitly or expressly broadens the scope of their dispute, the so-called the forum prerogatum, choice of the parties. This happened in one case, the case between Ghana and Cote d'Ivoire, maritime boundary limitation in the Atlantic Ocean, where the party had implicitly broadened the scope of their dispute to also include dispute on international responsibility for hydrocarbon activities in the disputed area. So not just the limitation, but also international responsibility. And one very important provision in UNCLOS, which is overlooked by even a legal expert, is Article 293, paragraph 1, applicable law. ITLOS may apply not only the 1982 Law of the Sea Convention, but also other rules of international law not incompatible with the convention itself. So this rule may be public international law in general, the law treaties, and as I'll tell you later on, international human rights law. Next, please. Examples of international agreements outside ITLOS that confer jurisdiction on ITLOS includes the 1993 FAO compliance agreement against IUU fishing, the 1995 UN fish stocks agreements, the 1996 Protocol on Convention on Prevention of Marine Pollution by Dumping, Article 25 of the UNESCO Underwater Cultural Heritage Convention, and most recently, the draft BBNJ Convention. The formula used there is that the dispute settlement part of the 1982 Law of the Sea Convention shall apply mutatis mutandis to any dispute between state parties to these agreements concerning the interpretation or application of these agreements. And here we come a very crucial part, whether or not the parties to such agreements are also parties to UNCLOS. So it means that parties to the examples of the agreements I mentioned, which are not already parties to the 1982 Law of the Sea Convention, may, by provision of this formula, become subject to the jurisdiction of ITLOS if they somehow become party to these other agreements. So next, please. There are two types of jurisdiction, that is contentious jurisdiction to settle dispute between parties and advisory opinions jurisdiction. The 1982 Law of the Sea Conventions specifically provides advisory jurisdiction to the seabed dispute chamber by virtue of Article 191 of the Convention. So the chamber may render advisory opinions on legal questions at the request of the Assembly and Council of the International Authority regarding the activities in the area. As for the full bench of ITLOS itself, in 2015, the full bench of ITLOS interprets Article 21 of its statute as allowing it to render advisory opinions on all matters specifically provided for in any agreements which confer such jurisdiction on ITLOS. So in that case, sub-regional fishery commissions in West Africa conclude agreements to refer to ITLOS a request for advisory opinions on legal questions regarding the rights and obligations of coastal states and flag states regarding fishing in various maritime zones. So this one has been interpreted as allowing full bench ITLOS to render advisory opinions, although the convention itself does not specifically provide such jurisdiction to ITLOS itself. So next one. The pros and cons of ITLOS versus ICJ arbitral tribunals. This issue has become seminal topics in many classroom seminars, even exams itself. Articles 280, 281, 82, 87 to 88 of the conventions allow disputing parties autonomy to choose their preferred means to settle dispute regarding interpretation applications of the convention. The principal choices are specifically mentioned in Article 287. There are ITLOS, the ICJ, and arbitration, except where ITLOS or the Seabed Dispute Chamber has exclusive jurisdiction, as I already mentioned. So these choices are to accommodate four main competing concerns at the Third Conference on the Law of the Sea that drafted the 1982 Law of the Sea Convention. One group of states preferred ICJ in order to ensure uniformity of international case law. Another group prefers specialized Law of the Sea tribunal with access by non-state as well, for example, by state enterprises engaged in deep seabed mining. Yet another group of states would prefer arbitration in view of its flexibility regarding the choice of procedure and arbitrators. And then the other group of states would prefer a special procedure for each main categories of Law of the Sea dispute, for example, fisheries, maritime boundaries, and marine environments. Next, please. As a result, Annex 7 arbitration is the so-called fallback or default dispute settlement mechanism if the parties have not accepted the same procedure unless the parties themselves otherwise agree. It is interesting that special arbitral tribunals under Annex 8, composed of scientific and technical experts for disputes regarding fisheries, marine environment protection and preservation, as well as marine scientific research and navigation, have not been resorted to from the beginning until now. Next, please. Please look carefully at the so-called first choice of state parties to the Law of the Sea Convention. 20 states have chosen ITLOS as the first choice. 6 states have chosen the ICJ as their first choice. And look closely, Honduras and Nicaragua are among those which have chosen the ICJ as their first choice. I'll come back later on. Annex 7 arbitrations is chosen only by 5. And Both ITLOS ICJ are chosen by several states. ITLOS Annex 7 arbitration only by Canada. Next, please. Other Guatemalan states have chosen all mechanisms without preference. ITLOS itself is chosen as the first choice in specific disputes, in specific case or specific category of dispute, for example, by St. Vincent and Grenadines in the case of prompt release of vessels. As a matter of law, where two parties select more than one common forum, but in a differing priority, then the choice of forum would be left to the applicant state. Next, please. There is one frequently asked question: why the ICJ has been dealing with Lower Sea cases more often than it lost. I have looked and studied carefully, and I have found Nicaragua as a very interesting case for case study purpose. Nicaragua have been involved in 15 cases before the ICJ to date, including as interveners in proceedings. 6 cases are against Costa Rica, 5 cases against Honduras, 3 cases against Colombia, including 2 currently pending cases in the ICJ against Colombia. The only other cases is the one against the USA in the classic case of military and paramilitary activities against Nicaragua, decided by the ICJ in 1986. What I have found is that, firstly, Nicaragua, Costa Rica, Honduras, and Colombia, in the case Colombia, until November 2012, are party to the Organization of American States, 1948 Pact of Bogota, Article 31 of which automatically recognized the ICJ compulsory jurisdiction over disputes among them. So it's natural that Nicaragua, Honduras, Costa Rica resort to the ICJ in order to preempt any possibility of objection to jurisdiction. The second point I would like to point out is that cases that involve Lower Sea disputes submitted to the ICJ also very often involve territorial disputes between the parties. The third point is that Colombia is not party to the 1982 Lower Sea Convention. So Nicaragua, rightly or wrongly, did not find it appropriate to bring Colombia to ITLOS instead of the ICJ. Next, please. Now look at the other Lower Sea cases pending before the ICJ. The case between Somalia and Kenya, as many of you may have known it already, Kenya has disputed the ICJ jurisdiction in that case. Guatemala and Belize. Here, there is also the element of territorial dispute, not just maritime claim. And last Friday, Gabon and Equatorial Guinea brought their dispute to the ICJ by virtue of their special agreements, asking the ICJ to interpret the conventions between France and Spain in West Africa in the year 1900, 1900, whether these agreements have the force of law regarding limitation of their common maritime and land boundaries and sovereignty over 3 named islands. Next, please. Before I discuss about arbitration, I would like to sum up that maybe several states, they don't understand that they can also bring disputes to ITLOS, despite the fact that the other party to dispute is not party to the 1982 Law of the Sea Convention, because Article 20 and 21 of ITLOS statute allow that possibility. Regarding arbitrations, it is often preferred by some parties because they have the choices over arbitrators. And for some of them, this is more acceptable to their constituency back home if they somehow can explain to the people at home that no, they are not subjecting their dispute to supranational body, but to some kind of arbitration mutually set up by disputing parties. And one benefits for arbitration is that the arbitrations may set up their own rules to have some kind of more confidentiality and as well as prohibit third-party intervention. And these procedural rules may not be available in the case of resorting to the ICJ or to ITLOS. Next, please. The advantage of the ICJ and ITLOS. We are established tribunals and courts with standing rules of procedures and benches of elected judges at permanent premises. The parties don't have to pay fees, don't have to pay anything for judges, which is different because if the party resort to arbitrations, they have to pay for the premises, they have to pay for arbitrators as well as secretaries' premises, which are very expensive. And even more interesting is the fact that disputing parties that have chosen arbitration instead of ICJ or ITLOS often fail to agree on the choice arbitrators, and they have returned to ITLOS for the ITLOS president to appoint the remaining arbitrators. Just look at arbitration between Philippines and China in the South China Sea dispute. 4 of the 5 arbitrators were incumbents or former judges of ITLOS. So instead of coming directly to ITLOS, they went to arbitration, in that case, Philippines. And it turns out that most of arbitrators are somehow members of ITLOS or former member ITLOS. Next, please. ITLOS and ICJ, with due respect to my colleagues, ICJ has a longer record in international dispute settlement. ITLOS is supposed to be more specialized regarding the law of the sea. And ITLOS has 21 judges, which apparently are more representative of the legal system of the world. And we are not elected by UN Security Council. And we are much faster in rendering our judgments. For example, in the limitation between Myanmar and Bangladesh, it took ITLOS only 2.5 years from the start to finish for us to render our judgment in that case. To date, the ICJ, not ITLOS, has been chosen where a disputing party is not party to UNCLOS. But as I already explained, the parties have ignored the fact that Articles 20 and 21, 22 of the ITLOS statute allow non-parties to the 1982 Law of the Sea Convention to come to settle the dispute between them in ITLOS 2. Next, please. Now, as a matter of record, ITLOS has decided every law enforcement from release cases. ITLOS also have been dealing with cases regarding the detention and confiscation of ships beyond the issue of prompt release. In other matters, for example, boundary imitation, fishery dispute, and marine environmental protection, there is competition between the different forums, ICJ, ITLOS, and arbitrations. Next, please. What are ITLOS contributions to the law of the sea to date? One major contribution is in the limitations of contentious beyond 200 miles. The first case decided by any court in this area is the Bangladesh-Myanmar cases in 2015. This is very helpful because if you just follow the procedure of having the Commission on the limit of contentious to settle the so-called outer limit of contentious margin beyond 200 miles, will take decades before the Commission's finish its job. So by coming to ITLOS, for ITLOS to determine the boundaries, direction of contentious beyond 200 miles, it will help the parties understand where the rights and obligations in contentious beyond 200 miles lies. It is ITLOS that also explain what the gray area in contentious beyond 200 miles, but within another state, exclusive economic zone means. So this is a new regime that somehow explained by ITLOS to the international legal community. Next. Next, please. And one very sensitive issue concerns hydrocarbon activities in overlapping areas. Here ITLOS explained the rule in the case between Ghana and Cote d'Ivoire. But you must be very careful. You have to look at not only the judgment on the merits, but Provisional Measures Order 2015. They explain what the state in dispute need to do regarding their activities in overlapping areas. If you look only at the judgment on the merit case, you have to be mindful of the fact that ITLOS in that case only explain what it means when it decide against Ghana, request to file Cote d'Ivoire, against Cote d'Ivoire's request to fight Ghana's violations of international legal responsibility. And then you have to look at the context of the Judge Pierre's separate opinions to explain why ITLOS proceed in that way. Next, please. IU fishing. This is a big issue for coastal states as well as the FAO. ITLOS explained in several cases the ground rule coastal state can take measures to suppress, prevent, and punish IU fishing. This appears in Virginia GE case as well as advisory opinion requested by sub-regional fishery commissions in 2015. Next, please. The 1982 Law of the Sea Conventions, Part 11, was invented for benefits of common heritage of mankind. The convention foresees possibilities in which developing countries may engage in deep seabed mining. And there are risks involved. The advisory opinions of ITLOS rendered in 2012 explain technical, financial, as well as other implications for developing states, as well as other sponsoring states to consider when they wish to engage in deep seabed mining. This opinion effectively provides guidance to states' interest in deep seabed mining, especially the ring states, concerning the extent of their liability. And this is very helpful for the future of deep seabed mining. Next. As the Lord Sea Tribunal, ITLOS has on many occasions stressed the importance of conservation of marine environments, as well as treating marine resources as part of the marine environments. The elements of prudence and precautionary approach has been stressed many times by ITLOS. And we have also indicated that the obligations to conduct an environmental impact assessment, or EIA, is a direct obligation under UNCLOS and a general obligations under customary international law. Next, please. Of course, there are several limitations elaborated by the convention itself. First of all, look at Article 297, which imposes several automatic limitations on commercial jurisdiction of ITLOS. It is very long and very complex, so I just refer to the article for you to look very carefully at the provisions of the convention itself. I will not elaborate it here because it will take maybe half an hour at least. So the next one, 298, optional exception, not automatic, optional exceptions. So when states become parties to the conventions, they may declare that they do not accept ITLOS jurisdiction in certain category of disputes. First of all, sea boundary delimitations, or those involving historic bays or titles. Secondly, military activities, law enforcement activities, etc., etc. And thirdly, the convention itself prevents dispute under consideration of UN Security Council agendas from being settled by UNCLOS ITLOS, unless the Security Council allowed ITLOS to settle the dispute. Again, you have to be very careful because 42 state parties to UNCLOS have declared this kind of optional exceptions to jurisdiction of ITLOS. But ITLOS has been very careful to interpret the scope of allowable, permissible optional exceptions under 298. Next, please. The so-called mixed disputes means dispute that concern not only the Lower Sea, but territorial dispute over sovereignty as well. Here, the convention does not explain whether ITLOS can proceed to adjudicate on this mixed dispute. But the legal literature, including writing by former president of ITLOS and former registrar of ITLOS, say yes, ITLOS may have jurisdiction over any dispute, including mixed disputes, provided that the so-called territorial dispute is merely ancillary to the dispute, the real dispute before ITLOS. And Article 2021 of the ITLOS statute itself made it clear that this is possible. So next, please. So let's come to cases that should have come before ITLOS, but have not so far come before ITLOS. Violations of Article 73, imprisonment of fishermen for illegal fishing in exclusive economic zone. There are laws in several countries. I cite as an example the law in one African countries that impose imprisonment of 20 years for illegal fishing in EEZ, or a fine of $435,000 US. But if the fine is paid, the sentence will be suspended. In one Southeast Asian country, fishermen are subject to 6 years imprisonment and a fine of $1.4 million US each. These provisions are clearly violate provisions of Article 73, paragraph 3 of the conventions, but no case has come before ITLOS in this regard. I presume that this is because fishermen themselves don't have bargaining power to ask the flag state or the state of nationalities to bring cases before ITLOS. Cases that come before ITLOS for prompt release involve ships, and ships are very expensive in terms of value as well as the cost for the ship owners as well as charterers of the ships. So my point here is, if the flag state don't intervene for some reasons, then there is no reason why state of nationality of the fishermen may intervene to exercise diplomatic protection on behalf of the fishermen. One cases and one indications in this regard is the Virginia G case. I already mentioned the paragraph in questions. So you see the cases coming before ITLOS involving applications by the flag states are often challenged on the ground that the flag states are not the same state, are not also the state nationality of the crew or charterers. ITLOS said that challenge is wrong because ship is a unit, and under one unit, it is controlled under jurisdiction and management of the flag state. But my point here is that the doctrine of ship of units does not necessarily apply where the flag state do not intervene to protect the right interest of nationals of other states. Next, please. The mining course was supposed to be finalized by the International Seabed Authority last year, but because of COVID, it is still subject to considerations of the authority. When it is finalized, then the Seabed Dispute Chamber will have to consider disputes under mining codes for this seabed mining in the areas. Another cases that could come up in the future concern Article 82, payments and contributions by coastal state as regard exploration, exploitations of non-living resources of their potential beyond 200 miles. This is new, never happened before, and the dispute could be between the coastal state, beneficiary states, especially the Robin state, as well as International Seabed Authority. Another dispute in which the submarine cable industry has been trying to find common ground with International Seabed Authority is the accommodations between the use of the seabed to lay submarine cables and activities in the area as regard the seabed mining. Because Article 87, 1C and paragraph 87.2 of UNCLOS recognize freedom of the high sea that includes the laying down of submarine cables. With due regard to other activities on the high sea, however, Article 147.1.3 under Part 11, the area, use the standard reasonable regard for other activities. Due regard is due regard, the same thing as reasonable regard. And how would you reconcile any position in conflict of uses in this kind of activities is something that the tribunal or the seabed authority will have to deal with in the future. So next, please. New fields, BBNJ. This is still subject to negotiations. So once it is finalized, we hope that ITLOS will have a role to play in this regard. Sea level rise. Here there is possibility for ITLOS to render advisory opinions on the impact of sea level rise on maritime boundaries, statehood, especially for small island states, as well as the rights and interests of persons affected by sea level rises. And Professor Alan Boyd himself foresee possibilities for ITLOS to settle disputes between the parties as a result of sea level rise, pursuant to several provisions of UNCLOS that I have already point out in PowerPoint 286 to 88, 297 to 98, 192, 194, 207 to 12. So the point Professor Boyd is trying to say is that disputes between states in the case of sea level rise are not automatically or optionally excusable under the conventions, and the party, any party can bring that kind of dispute against another party to the convention before ITLOS. Next, please. Human rights at sea. Some lawyers say ITLOS is not the law of the sea, so it's not human rights court. How can ITLOS adjudicate law of the sea dispute that also include human rights aspect at sea? My answer is that yes, we can either give advisory opinions or adjudicate contentious case regarding human rights at sea. ITLOS has consistently explained that considerations of humanity must apply in the law of the sea as they do in other areas of international law. And at least in one case between Panama and Italy, Panama raised the issue of human rights in these pleadings, but unfortunately, the pleadings regarding human rights came at a late stage. It was not included in preliminary objections phase, and at early stages of the proceedings. So in the final submissions of Panama, Panama did not touch upon human rights, and ITLOS therefore did not find it necessary to say anything about human rights. But the possibility is there. You look at irregular migrations at sea in the Mediterranean, the issue of search and rescue, the issue of what is distress under Article 98 of the conventions, These are grounds for dispute to come before ITLOS, either between the parties as contentious cases or as request for advisory opinions. And there's also a course of action regarding human rights to a clean marine environment under Parts 12 and under Article 297 1C Constitution of ITLOS. Other human rights issues may arise. If you're interested, you can have a look at a manual published by UNODC, that is UN Office on Drugs and Crimes, published in the year 2000. Chapter 6 of that cover human rights in the marine domains, the rights of seafarers, etc., the duties of flag state of nationalities. These are disputes that may come before ITLOS, not only before treaty bodies such as ICCPR or before European Court of Human Rights. So ITLOS can, and we are willing to adjudicate and decide cases on human rights as well. So I think my time is up. So it's very long presentations, and I'm a bit in a hurry because of the time constraints. So please apologize for anything that I may have omitted to mention. Thank you. So
thank you very much. Thank you for everyone who attended. That was a really interesting lecture. I feel like I've learned a lot as well. So thank you very much. And yeah, do join us next week. We will have Professor Hilary Charlesworth speaking in exactly 1 week's time, but at 9 a.m. in UK time. So should also be suitable for people tuning in from multiple time zones to this lecture. So, but thank you very much, Judge Kittichaisaree. That was really informative and really interesting. So thank you.
Thank you very much, and sorry that I had to rush because I usually get used to 3 hours lecture, but we're talking about the 45 minutes, 50 minutes. But anyway, there are many interesting questions, and if you can send them to me, then maybe I have a look at it. Maybe I can have a chance to write maybe 1 or 2 books on that too.
Yeah, we'll be sure to do that, definitely. Lots of good
Okay,
questions.
thank you so much.
Thank you. Take care.
Bye-bye.
Bye.